Thank you, Chairman Sablan and Ranking Member Gonzalez Colon for holding this hearing today, and thank you to the panel for your testimony. I find myself unable to fully support 8 Res 279 because I believe wholesale rejection of the insular cases may have unforeseen or undesirable implications on the future relationship between the territories and the United States. I also do not feel personally comfortable signing on to a resolution that makes judgments on what precedents another independent branch of government can and cannot base their decisions on. However, I still want to express my sincere appreciation for the intent behind the chairman's resolution and my sincere gratitude for his efforts on behalf of the territories. It is undeniable that the cases contain outdated and racially biased language. Such language can be harmful, and I'm sure we'll all agree that we have a responsibility to distance ourselves from such outdated views, as well as a responsibility to do right by the people of the territories. In my opinion, rather than make moral judgments on the decisions of another branch of government, it would be prudent to use our powers as a legislative body to address the issues of the territories directly. Congress has better tools than a House resolution to make things right, and we have a responsibility to act rather than do things indirectly through the other branches of government. This is the most effective way to actively distance ourselves from the racist rhetoric of the past while making real and substantial changes. I also want to emphasize that we act in Congress line with the will of the governed. The residents of the territories each have their own opinions about their relationship with the mainland and their future, and express that to Congress. The DC Court of Appeals, in the case of Twaua versus United States and the American Samoan government, protected against what many in American Samoa, including the territorial government itself, consider to be an imposition of citizenship by judicial fiat. We simply cannot ignore the basic truth that the supermajority of people actually living in American Samoa vociferously oppose the case and the relief that it sought, and continue to oppose the forum shopping going on in the Fitise Manu case. One may disagree with racist tones underlying the insular cases, but do not abandon the wishes of the residents of American Samoa in the process. Finally, I want to point out that American Samoa is unique by virtue that it became the only United States territory by deeds of cession starting in 1900. The Matai, or local chiefs of Tutuila, the largest island in American Samoa, voluntarily ceded the island to the United States in 1904, and Manua followed in 1900, and Manua followed in 1904. Lieutenant Governor Talawenga Talofa. In the hearing materials and testimony submitted today, there are references to a pending decision in the 10th Circuit Court of Appeals on a Utah District Court as to whether or not American Samoans born in the territory should have birthright citizenship. While we anxiously await the outcome of this case, could you elaborate on what the DC Appeals Court held, that it was anomalous to impose citizenship over the objections of the American Samoa people themselves, as expressed through their democratically elected representatives?
Thank you, Ufatali, Congresswoman. That was the decision in the Twaua case. The DC Circuit held, applying the framework of the insular cases, that the decision on whether or not the Constitution applies has to be decided from the viewpoint of the governed. So from the viewpoint of the people of American Samoa in this case, whether or not the application of citizenship is practical and or anomalous to the culture of American Samoa. The evidence presented in that case led the court to conclude that applying the citizenship clause to American Samoa is both impractical and anomalous, and therefore it wasn't applied. And so that's the short answer to the question.